Yo, what's up, man? Monday, June 16th, 2025. That's my fish tank. Y'all hear that water right there? That's my fish tank. I got the best fish tank in the world. I got the dopest fish. I got dope fish in my fish tank. I got the best fish ever. Y'all want to see my cat? Y'all want to see my cat? Look at my cat, Luna. I missed it. All right, so look. Come here. Thank you for joining, coming to my channel. Thank you for subscribing. Please give this video a thumbs up if you like it. If you don't like it, you could give it a thumbs down, however you feel. Express yourself. You can follow me on Instagram at The Podcast with Soul, and you can follow me on Spotify at The Podcast with Soul. And I want to thank everybody for coming over, all my new subscribers. I appreciate you. So today in court, juror number 6 was removed by the judge. He was a black man, okay? Black male juror. Look, Luna, come here. That's my cat, Luna. Little Sean's cat. Both our cats. Black male juror was removed from the jury today after 6 weeks into the trial. There was some issues concerning him living in the Bronx, having a driver's license, a New York driver's license. And I guess at the time of the jury selection process, he was living in the Bronx, but he's since moved over to Jersey to be with his baby daughter and her mother. I guess he spends some nights over there. I don't know the full story, but what I do know is that he was removed from the jury. I want to give a shout out to all of my white followers. All of my white followers from the United States of America, from Europe, South America, all over the world. White people have supported my platform since 2018, when I first started my channel. White people have bought my merch, they bought my hoodies, my books, my shorts, my hats, my shirts, one-on-one mentorship calls. They came to my leadership and entrepreneurship and leadership conference in Miami. White people have supported my platform from the beginning and still continue to support, loan me money, full support. And I want to say to my white subscribers and my white followers, in no way what I'm going to talk about today do I make it a blanket statement and broad brush the whole white community, all the white people on the planet, for what I'm going to discuss today and what's going on in the Southern District of New York. Over the weekend, Puffy's attorney, a white woman, a white Jewish woman, I think, Alexandra Shapiro, phone number 212-257-4881. 212-257-4880. Wrote a letter. Let me set it up for you. On Friday, we were all in court on Friday. I was there Friday the 13th. And Judge Submaranian, who is the judge of Indian descent, India from India was very clear early in the morning before court started, before 9 o'clock or maybe a little bit after 9 o'clock, before they continued, before they introduced their first witness, which was the guy from Homeland Security. Judge Submaranian was very adamant, and he was very matter of fact, and he was determined and sure that juror number 6 was not going to be removed, that there was not a basis for juror number 6 to be removed because he was biased for whatever reason, and that the prosecution's argument to remove juror number 6 didn't rise to the level that juror number 6 should be removed. And Alexandra Shapiro also cited Supreme Court and other federal court cases where far more serious issues related to jurors had happened and those jurors weren't removed. So like this guy, juror number 6, this was small potatoes. And the judge says, no, he's not going to be removed. I've spoke to him twice. He's not going to be removed. He then said, let me think about it, and I may talk to him at the end of court today, maybe. But as for right now, he will not be removed. The end of court came Friday. The judge cleared the court and began discussion saying that juror number 6 was going to be removed. And this was a stark change, a drastic change from what he had said and who he had appeared, the stance that he had took, his position from the morning, where I don't think he had a chance to meet with juror number 6 in between what he said in the morning and what he said in the afternoon. It was as if he received some kind of phone call and just changed his whole position on juror number 6. Alexandra Shapiro, this is a 14-page document. This is public information. You can find this on Pacer. Wrote a 14-page letter over the weekend, and it's dated yesterday, Sunday, where she says, she starts out, Dear Judge Submaranian, the defense submits this letter in further support of its vigorous opposition to striking juror number 6, a black man. Mr. Combs would be substantially prejudiced by the dismissal of this juror. And because there is no factual basis to remove him, the court lacks discretion to do so. First, there is no question Mr. Combs would be severely prejudiced if the juror in question were removed and replaced by the first alternate. We have previously pointed out that this juror is one of only 2 black men on the jury. This is her letter. This is from Alexandra Shapiro. This is a white woman. I think she's of the Jewish faith. The federal prosecution team from the Southern District, New York, is made up of 6 white females. Emily Ann Johnson, Madison Reddick Smizer, Mary Christine Slavic, Meredith Foster, Mitzi Steiner, and Maureen Ryan Comey. 6 white females. There's, I think, 2 other members on the filter team, and they may have some supervisors there. All white females. Now, what Alexandra Shapiro also points out in her letter to the judge, and she mentions how he changed his mind from the morning to the evening, and she couldn't understand it either. Let's go through it. This is what Alexander Shapiro says about Judge Submaranian changing his mind from what he said in the morning to what he said in the afternoon. In light of the discussion in the morning, the defense was stunned when the court announced at the end of the day, in stark contrast to its extensive earlier remarks about why there was an understandable way to reconcile the juror's answers, that it believed the juror, Judge Submaranian, believed the juror was either unable to follow simple instructions and answer simple questions, or was shading the truth or being deceptive, and would dismiss the juror without further inquiry. Should the court, this is Alexander Shapiro, should the court exclude juror number 6 on the current record, it will no doubt have a chilling effect on minority jurors' willingness to serve in the future. But hold up, y'all, check this out. Now this is key. This is key. As I told you, this is the Southern District of New York. All 6 of the prosecutors prosecuting Puffy. Puffy is a foundational Black American like me, meaning that we can trace at least one of our parents, we can trace back to slavery in this country. We are not immigrants. We didn't come here. We were already here. This case was brought by Damian Williams, who was the U.S. Attorney of the Southern District of New York at that time, who was a Jamaican immigrant. He is not from here. He is from Jamaica. Shout out to all my Jamaicans. Kingston, Montego Bay, Ocho Rios, Dunn's River Falls, Spanish Town, Linstead, Emancipation Park. Y'all have been supporting me from the beginning too. This is in no way a diss to y'all. During the jury selection process, there's something that's called a voir dire. Let me read it for you. Now, the voir dire is a preliminary examination of a witness. Hold up, y'all. Turn that off. Sorry about that. A preliminary examination of a witness or a juror by a judge. The phrase voir dire literally means to speak the truth. In court, it refers to the process of determining whether a juror can serve fairly and impartially in a given case by asking the juror various questions. Voir dire. In law, voir dire is the process of questioning prospective jurors to determine their suitability for jury service. It aims to identify any biases or prejudices that might affect their ability to be impartial. The term itself in French means to speak the truth. The questioning of potential jurors. Both the judge and attorneys question potential jurors to assess their qualifications, knowledge of the case, and potential biases. Attorneys can challenge potential jurors for cause. An example, for cause, if a juror has a close relationship with a party involved in the case, meaning the defendant or the plaintiff. Peremptory challenges. Now, this is the good part. Attorneys also have a limited number of peremptory challenges or peremptory strikes, which allow them to dismiss jurors without needing to provide a specific reason. In essence, voir dire is a process designed to ensure that the jury chosen to hear a case is fair and impartial, and that any potential biases or conflicts of interest are identified and addressed before the trial begins. Now, check this part out. In Alexandra's letter to the judge, which she also requests a mistrial if juror number 6 is removed. Government's motion, Alexandra Shapiro, Puffy's lawyer, is saying this: the prosecution's motion continues a pattern of overreach, suggesting a discriminatory motive in challenging juror number 6. Although the court denied our Batson challenge and said it found no basis to suggest the government had a discriminatory motive when it sought to strike juror number 6, we believe that motive is supported not only by its remarkable decision to use 7 of its 9 peremptory strikes on black jurors, but also by the history of the investigation and prosecution, which has been characterized by extreme government overreach from the beginning. So 80%, the prosecution was given 9 peremptory strikes or 9 peremptory challenges, and probably the defense was given the same amount of peremptory strikes and peremptory challenges. The prosecution, the 6 white federal prosecutors, used 7 of their 9 peremptory strikes on black jurors. Now, remember, a peremptory strike, right? A peremptory challenge is a right granted to each party in a trial to remove a prospective juror without needing to provide a reason. It's a way for attorneys to eliminate potential jurors they might believe not be favorable to their case, even if the juror hasn't shown any bias or prejudice. So during the VOIR process, the 6 white federal prosecutors, white female federal prosecutors, used 78%, almost 80% of their peremptory strikes against black jurors. Now they just had another black juror removed. Since 1989, revealed that black Americans are 7 times more likely than white Americans to be falsely convicted of serious crimes. For starters, it is notable that Mr. Combs, one of the most successful and self-made black men in America, and a person who was an icon not just in the black community, but in the music industry, the fashion industry, and otherwise, was indicted by the Southern District of New York's Civil Rights Unit. When the unit was established, former U.S. Attorney Damian Williams was quoted as saying, this was all by Damian Williams, all of this was part of a coordinated effort to try to destroy one of the most successful black men in American history. All of Mr. Combs' ventures are entirely legitimate, and the government has never suggested otherwise. Peremptory challenges allow attorneys to build a jury they believe will be more receptive to their arguments. Unlike a challenge for cause, which requires a specific reason for exclusion, like bias or inability to serve, a peremptory challenge does not need justification. Attorneys use them to remove jurors based on intuition or beliefs about potential bias, even if those beliefs aren't easily articulated. The potential for bias. While peremptory challenges allow for flexibility in jury selection, they can also be used to exclude jurors based on protected characteristics like race or sex. The Supreme Court has ruled that such discriminatory use is illegal. A Bastin challenge. If a party believes a peremptory challenge was used to discriminate based on race, they can challenge it under the Bastin versus Kentucky. And Alexandra Shapiro already states here that Puffy's legal team challenged on the Bastin claim, but I think was denied. Let's go to it. I got it right here, y'all. Although the court denied our Bastin challenge and said it found no basis to suggest the government had a discriminatory motive when it sought to strike juror number 6. We believe that motive is supported not only by its remarkable decision to use 7 of its 9 peremptory strikes on black jurors, but also the history of the investigation and prosecution. That's where we are. The black population in the city of New York, I think it's like 20%. So on a 12-person jury, 20% would be, what, 2.5? You'd have to have 2.5 black people on the jury if you're going to represent based upon the racial demographic percentages in this city. But that's the real deal. That's the real deal. So, that's what we got. Thank y'all for coming. Peace.